Thank you all so much for joining us, the Rocky Mount Alumnae Chapter of Delta Sigma Theta Sorority Incorporated, during the Economic Development's Estate Planning webinar. We want to take a moment to bring a few housekeeping matters to your attention before we get started. All attendees have been muted in an effort to minimize background noise. Any questions you may have, please use the question and answer feature located on your Zoom controls to submit those. We will try to answer as many questions as possible at the conclusion of the webinar. If at any time during the Zoom, your audio or your video starts glitching out, the first thing to do is to log out and to log back into the meeting to see if that provides you any relief. Without further ado, I'd like to hand the meeting over to June Kearney, our Rocky Mount Alumnae Chapter, President of Delta Sigma Theta Sorority Incorporated. Thank you.
Thank you, Deidre. Good evening, everyone. I am June Kearney, President of the Rocky Mount Alumnae Chapter of Delta Sigma Theta Sorority Incorporated, and I would like to humbly welcome you to our estate planning webinar. We are delighted to have you join us as we delve into crucial aspects of estate planning, such as wills, trusts, power of attorney, and estate administration. Our discussion will be led by our esteemed speaker, attorney Tia Hudgens-Taylor. Today's session is designed to empower you with knowledge and strategies to protect your assets, ensure your wishes are honored, and provide for your loved ones in the future. Attorney Taylor brings a wealth of expertise and experience in estate law, and she is ready to share valuable insights and answer your questions. Thank you for being a part of this important discussion. Let's embark on this journey together towards securing our legacies and achieving peace of mind. I hope you enjoy the webinar. I will now turn the virtual floor over to Felicia Taylor, Chair of the Economic Development Committee, to introduce our presenter. Felicia, you're on mute.
My apologies. Our presenter, Tia Hudgens-Taylor, is an associate attorney at Lassiter & Sperati, PLLC. Her areas of practice include real estate, estates, family and domestic, criminal, juvenile, traffic, and corporate law. She is a native of Rocky Mount and has returned home after law school to serve her hometown and surrounding areas. She's passionate about giving back to her community and is committed to advocacy. I'll now turn it over to attorney Tia Hudgens-Taylor.
Good evening. First, I want to say thank you all for having me. Thank you for the opportunity to present on some important information. I will start by saying that typically on a day-to-day basis, I'm in court and I'm standing in front of hundreds of people. And I do it with ease, but for some reason, when I get into these presentation settings, I get nervous. So y'all bear with me. But my mother-in-law had the opportunity of sharing a little bit of information about myself. However, I do like to add, just to allow people, the opportunity to understand how I got here. And so I graduated from Rocky Mount High School. If you know me, you know I am a diehard advocate for Rocky Mount. I love everything about Rocky Mount, and I'm committed to, seeing our community be a better place. Upon graduation from high school, I got a basketball scholarship to go to Queen's University of Charlotte. And there I majored in sport management and minored in pre-law. And so I knew I wanted to be a sports attorney, that I knew I wanted to do that. But I figured that if I was going to do that, I needed to be at least in the Charlotte area. And for those of you who know me, I couldn't be that far from my mama any longer. So as I went to law school and, I completed a lot of different internships and externships and residencies. And that's when I decided I wanted to go back home because I could use the information that I learned to help my community. My community has poured so much into me, and so this is my opportunity to pour back into my community. Upon graduation from law school and passing the bar, I started at a general practice law firm here in Rocky Mount, pretty much doing the same thing that I'm doing now. I then went to the district attorney's office and served as a prosecutor under the leadership of Robert Evans for about 2 years. And then I was presented with my current position at Lassiter and Sparati. And so I get to practice in a lot of different areas, and that's something that I enjoy because, people can come to me with different issues. Some, may start out as a family law issue, end up being a real estate issue, and I get to really help people figure those things out. But today I want to talk about estate planning. And oftentimes we don't want to talk about it. We don't want to hear about it. We don't want to think about it. It's something that we avoid at all costs, but avoiding it can cost us, especially in the Black community. And I always use my dad as an example. I said, Dad, I think it's time for you to start thinking about your will. And he said, oh, well, I don't plan on, needing that anytime soon. But I always tell people, you never know. And so I want to share some general information on a few estate planning tools that I think will be helpful. And it's my hope that people will use this information to think about these things and then take the next step to put some of these instruments in place. So some of the topics that we will cover today will be power of attorney, wills, estate administration, and trust. As I'm going along, feel free to drop your questions in the Q&A box. And then at the end, I'll come back and try to answer some of those questions. I will start out with a couple of disclaimers. This isn't legal advice personally for you. So I would suggest or recommend speaking with an attorney for your specific situation. And secondly, I am a North Carolina licensed attorney. So the information that I'm given is pretty much based off of North Carolina law. So if you reside in a different state, I would advise you to speak to an attorney in your state to figure out how these things, work with your state law. So we can go ahead and get started with our first topic. I'm going to share my screen. All right. So the first thing I want to talk about is power of attorneys. A power of attorney is basically a document in which you name an agent to make decisions for you. And most people, we can manage our affairs right now as healthy adults, but sometimes life-changing events happen. And so we need to think about who's going to manage my affairs if I'm in a car accident, or if I have a stroke, or if I'm in a coma. And maybe not even on a serious, that serious of a note, but who can handle my affairs if I'm out of the country on vacation and something needs to, be signed? We need to think about, who can help me and who can step in to do that. And so now, while you're healthy, that's the best time for you to put these things in place and think about who should handle your affairs in the event that you're unable to do so. So there are two types of power of attorneys that I want to discuss. And the first one is the healthcare power of attorney. And it's pretty much exactly what it's called. It's a document where you name an agent to make healthcare decisions on your behalf. You can also provide some type of guidance and limitations within that document. You can think about whether or not you want to be an organ donor, your preferences regarding life support, feeding tubes, whether you want to be buried or cremated. And this document oftentimes is required by doctors in order for them to share information with your loved ones or with the agent that you have named. One thing that I always recommend when people get their healthcare power of attorney is to take a copy of that document to your doctor's office. That way they have it on file. So if you, for example, name your daughter as your agent and she calls up, your doctor's office is able to pretty much pull that document up and see that they have the ability to speak with her on your behalf. The second type of power of attorney is a durable power of attorney. This is a document where you name an agent to act on your behalf regarding pretty much everything non-healthcare related. This could be your banking matters, your business matters, any legal matters. It could be real estate, taxes. So pretty much everything outside of healthcare, this durable power of attorney, you can use this document to name someone to be able to act on your behalf. For both of these documents, when you're naming the agent, you want to choose someone you trust, and you want to choose someone who you believe will make the best decisions or make decisions, on your behalf that's beneficial to you. So it's really important to think about who that person is. Think about the responsibility that comes along with giving, the power of attorney, and really just selecting, the best person that can help you out in the event that you're unable to do so. Another thing about a power of attorney is once you pass, that document is no longer effective. It's only in effect while you're living. So again, those are the two types of power of attorneys, the healthcare power of attorney and then the durable power of attorney. And just making sure that you choose someone that you trust. The next topic we'll cover would be wills. And so when I'm talking about wills, I'm not talking about a living will. Living will kind of goes back to that healthcare power of attorney when you're thinking about those life-sustaining measures. When I'm talking about wills right now, I'm talking about your last will and testament. And this is basically a document in which you can specify your wishes. And so I always tell people, think about what you own. Think about your real property, land, houses, and then think about your personal property, whether it's your car, your jewelry, your clothing, your furniture. And you want to think about where you want those things to go. So creating a will allows you to make the decision. Without a will, your property will be distributed based on North Carolina law. And people say, well, that's how I want it to go. I want it to go to my spouse and my children. But I always tell people that the law can change at any time. And so by creating a will, you are making sure that your property is being distributed how you want it. Also, along with the personal property, you can think about, for our sorors up here, your Delta paraphernalia, whether you want that to go to your chapter or whether you want it to go to Soror Taylor, however the case may be, these are the things that you can list within this document to make sure that, it happens how you want it to happen. You also want to think about who you want to name as your executor. And this person will have, a huge responsibility. And so again, just like the power of attorney, you want to pick somebody that you trust. The executor will have the important task of tracking down your belongings, getting in touch with the individuals that you've named in your will, and making sure that your estate is administered as you specified in your will. A lot of people may not have a will, and then we do have some people that may have a will. If you already have a will, I would suggest taking some time just to sit down and look back over it, because there are certain life events that may have happened. It may have been a while since you've updated your will. I've oftentimes had people come in my office and their will was drafted before I was even born. And so I always tell those people, I think it's time to sit down and revisit these things. Someone that you may have named in your will may have passed away. You may have gotten divorced. You may have gotten married. You may have gotten remarried. You may have relocated to a different state. You may have additional children. There also could be changes to a beneficiary. There may be some things that you want to switch around. So every so often, it's important. Make sure you sit down, make sure you look at your will, and make sure it still aligns with what you want and what your wishes are. And then the next thing, this kind of goes along with the will, but the next process is the estate administration process. And so this process takes place after you have passed away. And whether you pass with a will or without a will, it's important that your estate is administered. And so through this process, a personal representative will be named by the clerk, whether it's your executor or your next of kin, but that person's appointed by the court. And what they need to do is they need to collect your assets. They need to give public notice to your creditors. They need to pay any valid debts that you may have. And then they want to distribute the personal property to the proper person, whether it be the people that you've named in your will, or whether it be the people that are gonna, take the property as heirs to your estate. And so I want to talk about property and, how they go through the estate administration process. So property that typically goes through the estate administration process would include vehicles, bank accounts, stocks and bonds, furniture, jewelry, any tools and different things like that. Then you have property that doesn't typically go through the estate administration process. And that's any property that's held with the right of survivorship, like your insurance policy, your retirement account, or any joint bank accounts. Land and houses, they typically do not go through the estate administration process. However, if the estate has some debts that need to be paid off, that real property can be pulled back in order to satisfy those debts. So, oftentimes, people will need to get permission from the clerk in order to pull that house back in, where they need to sell the house in order to create some type of asset to pay the claims and debts of the deceased individual. And on my slide, I have fiduciary duties, and I have some exclamation points beside it, because the executor, if you're named as the executor, or administrator, if you're the personal representative for the estate, there are certain things that you have to do, certain rules, certain accounts that you have to keep up with. You want to make sure that you're keeping an inventory. You have to keep an inventory of the descendants' assets. You have to keep a receipt of what's being paid out, who's getting what, and then just making sure that you're keeping the courthouse updated on what's happening with the estate. And I highlight this because this is a big task. This isn't something to take lightly, because the executor or the personal administrator can be held liable if they aren't doing what they're supposed to do. When they're appointed by the court, they take an oath that they're going to carry out their duties and that they're going to follow whatever rules are in place. The clerk will have certain deadlines of when things are due. And so going back to your will, that's why it's important that you choose someone as your executor that you trust, and someone that you feel is qualified to carry out this estate administration process. Some personal representatives, they choose to do it themselves. A lot of them will go to your local courthouse and go to the estates division, and you'll speak with the clerk, and they can give you a packet of information that kind of guides you on going through the estate administration process. But one thing the clerks can't do is they can't give you any legal advice. So some personal representatives, they get that packet and they decide, hey, I'm going to do this myself. And then some decide, hey, I'm going to take this to an attorney to help me throughout this process. So think about that. If you're going to need that help, if you are the executor for someone. But this, again, isn't something that, you want to take lightly. This is something that you want to make sure that you're choosing a qualified person. And then this is the topic that I feel like I'll get the most questions on, and that's trust. So a trust is an instrument or an entity in which a person can place their assets. People call me every week and say, hey, Tia, I need to get a trust. I need to put my house in the trust. I need to put my parents' house in the trust. I need to get a trust. And so my first question is, well, why do you think you need a trust? And the response is often, well, my boyfriend's dad's sister said that a trust is the best thing to do. That's often the answer that I get, or something similar to that. But it depends on your specific situation. It depends on what goal you're trying to reach. The biggest advantage, and typically the reason why people want to put their property in a trust, is to avoid that probate and estate administration process that we just talked about. For example, I told you the house doesn't typically go in the estate, but if there are some creditors that need to be paid, that house gets pulled in to satisfy that debt. However, if you have your property in a trust, you don't have to worry about that house getting pulled in, and having to be sold and those claims being paid off by the house. So that's typically the number one reason why people want to get a trust, is to avoid that probate process. The other advantages to having a trust is privacy. When you go through the estate administration process, that information is public record. People can go down to the courthouse and can look at that estate file and see how much money you had in your bank account, see what property you own, and etc. But with the trust, that's private. That's not something that they can typically go down to the courthouse and look at and see what assets you have. You also have more control over a trust. You get to tailor the terms of the trust and decide, how you want things to go. For example, I may have parents that say, hey, I want my son to get $5,000, but I want it to wait until he reaches the age of 21. A trust allows you to make those certain terms and conditions for your trustee to abide by. And so you have more control in kind of, setting your own terms. There are two types of trusts. You have your revocable trust and then your irrevocable trust. Your revocable trust is a trust that you can make changes throughout your lifetime. You can add assets, you can take things out, you can sell things in the trust, you can change who the beneficiaries are, you can change those terms and conditions that you stated. You pretty much can, modify it. And then you have the irrevocable trust. Once that trust is made and you have those terms and conditions, you can't make any changes, can't make any modifications. That trust is set up, and that's pretty much the way it stays. A lot of people choose an irrevocable trust, one that you can't change, for some of the tax benefits. I can't answer, what the tax benefits are. That would be someone you would want to talk to a tax professional in regards to that, to see how that would impact you, and what the benefit may be. But just know that there are two types of trusts: that revocable trust and then the irrevocable trust. A lot of people, like I stated, think that a trust is better than a will, but again, it all just depends on your own personal situation and what goal you're trying to achieve. And then the last thing for trust would be, I have acceleration. I feel like a lot of people may call up their attorney and say, hey, I need to put my house in a trust. However, you may have a mortgage on your property. And if you look at your deed of trust, there may be a little clause in there that states that if you transfer this property, your mortgage payment is accelerated, and that loan is due immediately upon transfer. And in order to put your property in a trust, you have to deed it out of your own individual name and deed it to the trust, therefore creating a transfer. And so you want to be careful. You may need some type of permission from your lender that you can transfer this property, but you want to be careful, if you have a mortgage on your property, with transferring that property out of your name and into the name of the trust. So that way you're not, accelerating your payment and making your payment due. So a lot of times with that trust property, it's typically property that is paid off, property that you don't have a mortgage on, unless you have gotten some type of written or consent from your lender that you can transfer this property. I don't have a slide for it, but another thing that I want to discuss and that I often get a lot of questions about when we're talking about estate administration is the Medicaid look back period. So a lot of individuals, they, may have older parents or, may just, be reaching the age where they're trying to figure out what to do with their property and with their assets. So the Medicaid look back period is a time frame in which an applicant's financial records are reviewed to determine if they're eligible for Medicaid. And so in North Carolina, they will look back 5 years to see what property you have owned and your assets. And it doesn't disqualify you for Medicaid, but it kind of gives them a baseline and kind of sets the stage to determine whether or not you're eligible for Medicaid. And so oftentimes I advise people that, you may want to start looking at transferring this property into a trust or transferring this property to your children in order to avoid that 5-year look back period. Because you never know if you may need to go into a nursing home or whatever the case may be, but they will look back within that 5-year period to see what you own within that time frame. And so just to kind of go back over everything, we have your power of attorney. Remember, that's a document in which you are naming an agent to act on your behalf. You have your healthcare power of attorney, which covers your healthcare needs, talks about organ donation, being cremated or buried, any life-sustaining measures that you want in place. And then you have your durable power of attorney. That's covering pretty much everything outside of healthcare. Banking matters, legal matters, real estate, taxes. And then another important document is a will. That's a document in which you are specifying where you want your things to go, who you want them to go to. One thing I forgot to mention with the wills, your will can be very specific or it can be very general. For example, you can say, hey, I want everything to go to my 3 children and be split equally. Or you can be very specific to say, I want this pearl necklace to go to my granddaughter. I want this book to go to my son. It can be very specific or it can be very general. But this is just your opportunity to lay out whatever your wishes are. And then we talked about the estate administration process. That's pretty much the process that happens after you pass, making sure your debts are paid, making sure that your property is located, and then making sure that it's distributed however you want it to be distributed. And then the last thing we talked about were trusts. And the 2 types of trust, you have your revocable trust, the one that you can modify and make changes to, and then your irrevocable trust, the one you can't modify. And a trust is an entity in which you can transfer your property out of your name and place within this trust. And so those are kind of the 4 big instruments that I think are important for estate planning. And those are typically the things that I tell people, sit down, think about, and make sure you have these things in place. So now we can go to some questions and start answering some questions. And so the first question I got was whether or not a spouse exceeds the need to have a power of attorney or healthcare power of attorney. So oftentimes, if you go to the doctor, they may be more willing to speak to a spouse, because that's the next of kin. However, I think it's important to make sure that you have a legal document in place that specifies who can make decisions, and answer questions on your behalf. So I would recommend getting a power of attorney or healthcare power of attorney, because it doesn't necessarily exceed, a spouse doesn't necessarily exceed those documents. You may have some doctor's offices that, say, hey, you're the spouse, but without something in place, we still won't talk to you. So I think it's important to have one of those documents in place. And the next question I got is regarding trust. Can inherited property be placed in a trust? If you inherited the property and you're the sole owner of it, you can place it in a trust. If it's heir property and you own that property along with some other individuals, you can place your interest in the property within a trust, but you wouldn't necessarily be able to place the whole entire interest in a trust without the consent of everybody else. So for inherited property, you can place your interest in a trust. And then the next question I got was whether or not there are fees associated with ongoing changes to a revocable trust. So as far as at my law office, with any changes that are made, there are additional fees because with the trust, you'll have a trust agreement, and that's pretty much laying out who your trustees are, who your beneficiaries are. And so if you want to make changes and you want to take things out, you'll want to update that trust agreement. And so fees can occur for any ongoing changes that you make to your trust. And then I got another question about where do you file your paperwork and will it transfer across counties? So I'm not sure if you are, talking about power of attorneys or wills or different things like that. For a will, you don't have to file your will. I always tell people when you sign your will and it's executed, place it in a safe place, whether it's a lockbox, a desk drawer, or something of that nature. Just place it somewhere so someone can find it. It doesn't have to be filed with the courthouse or anything like that until after you pass. And so typically your will is administered in the county that you resided in or the county that you have property in. So, it may be a different county, so that paperwork will apply in that county. And then in regards to power of attorneys, those documents, can be transferred across different counties and they don't have to be filed. However, if you are handling a real estate matter, a power of attorney will need to be registered with the Register of Deeds before that real estate transaction takes place. The next question I got, are handwritten wills under your mattress or in a Bible legal? So North Carolina, they will recognize handwritten wills. However, there are certain requirements. I believe you need to have a person that can attest to your handwriting, and there's different steps to take place for that will to qualify. And so oftentimes I have a lot of people say, well, hey, I wrote out how I want things and I got it notarized. But I think it's important to speak with an attorney. That way you can actually get it written out. There's certain requirements. It has to be notarized and signed in front of 2 witnesses. And so I think it's just, it's best to go ahead and take those steps to get that will legally drafted versus going through the process of having a handwritten will probated. The next question is, I have designated beneficiary forms for my bank accounts and requirement accounts. Do you suggest a will even if you have designated beneficiaries? So for those bank accounts and those retirement accounts, if you have a pay on death person listed, or if you have a beneficiary listed for your retirement accounts, that's good. You don't need to include that in your will. along with updating your will and making sure you check back over it, I would suggest checking these policies as well and making sure that you have the correct beneficiary listed, making sure it's the person who you want it to be. Sometimes you may have started your job 30 years ago. Look back and make sure you have the correct beneficiaries listed on these policies. Next question, are power of attorneys liable for any fees or debts owned after the death of the family member? So I think this is probably more so an estate administration question. Whether that person, that executor or that personal representative is liable for any fees or debts. So the estate is liable for debts of the person that is deceased. The executor and the personal representative is not liable unless they aren't abiding by their fiduciary duties or they're doing things that they aren't supposed to do. That's when they can become personally liable for the debts. However, if they're doing everything that they're supposed to do, the estate is who covers the debts. And I hope that answered that question. If not, just submit another question. I'll try to answer it a little bit better. Next question is, if a legal decision maker, say adult children, if the medical decisions of the person, I don't know what that question is saying, so submit that question again for me, so that way I can answer it. Next question, can you provide average costs for power of attorneys, wills, and trusts? I will provide the cost for my office. So a general power of attorney, your durable power of attorney, and your healthcare power of attorney are $100 each. Your will is $200. And then your trust agreement, your trust will vary. It depends on how extensive your trust agreement needs to be, what's going to be included in the trust. And then you have to think about the costs that may be associated with transferring the property into the trust. For example, if you are transferring real property or a house in the trust, there's a fee that will be incurred for transferring, creating a deed to transfer that property into the trust. So the trust amount will vary, and it just depends on your specific situation and, what property you're transferring. Next question, if you will everything to your child, but you pass at the same time, can your will indicate what happens in that case? And how do you make the will apply if someone in the will predeceases or dies shortly after or during the same day? So within the will, we can create a clause that talks about if somebody passes at the same time that you pass or they pass shortly thereafter, and we can indicate where those assets should go if that were to happen. For example, we always think about if a husband and a wife were in a car accident and they pass at the same time or shortly after, we'll want to make sure that, there's somebody in place to take whatever that portion of your assets were. Next question, can a person be a dual power of attorney and a healthcare power of attorney? Yes, someone can serve as your durable power of attorney and they can serve as your healthcare power of attorney. You can choose the same person. I've had one situation where a lady had a sister who was a nurse, and so she preferred for her sister to be her healthcare power of attorney. And then her brother was a banker, and so she chose for her brother to be her durable power of attorney. So you can choose two different people, or you can choose the same person to add. Next question is, do you have any thoughts on revocable versus irrevocable trust, and what would you suggest? That's a question I can't really give a specific answer to without knowing more about your situation and what your goals are. So that would be a question that we would have to sit down and, look at a big picture of your situation to figure out if a revocable trust would be the best or if an irrevocable trust would be better. Okay, if a legal decision maker, say an adult son, disagrees with the decision of the healthcare representative, what happens? So whoever is named on that healthcare power of attorney to make that decision is, that would be the thing that should be followed, is whoever is listed as your agent. I oftentimes see situations where there are disagreements, and so sometimes that happens, but whoever's listed as your healthcare power of attorney, they should be the decision maker. They should be the ones making the decision. There are, and oftentimes within the wills, when you name an executor, or in your power of attorneys, when you name an agent, sometimes people choose to name two people to serve together. And if that's what you choose to do, that's fine. But I typically like for you to choose one person and then choose an alternate if that person isn't available. And the reason why is because sometimes when you choose two people to act at the same time, they may disagree. And right now they may agree, but if mom is in the hospital and it's a matter of life and death, daughter may say, hey, I think the doctor should do this, and son may say, hey, well, I think the doctor should do that. And so you oftentimes may run into that situation where they don't agree. And so sometimes this is a little bit more helpful if you just name one person and then name an alternate in case that person is unavailable. Next question is, roughly how much does it cost to alter a will that has already been filed to add a clause? And does a new will have to be created? So there's a document called a codicil, and that is where you can make amendments to your will. Roughly speaking, if there aren't too many changes, we typically charge $100 for a codicil. If you look back at your will and you feel like there's a lot of different changes that you need to make, I just suggest that people just go ahead and get a new will drafted. But you can alter, if there's like one clause that you just need to make a change to, we can do a codicil that will go along with your will to make that amendment to that clause. And then I got a statement that just says Medicaid look back. So I'll kind of just briefly go back over that. But in North Carolina, there's a 5-year look back period to determine your eligibility for Medicaid. And it doesn't determine if you're eligible, but it sets the stage. And so what they do is they look back within that 5-year period and look at your assets, look at what you own. It may be property or different things like that to kind of help them make their decision for Medicaid. Next question, if you have a trust and it's been less than 5 years, does the Medicaid look back period apply if something happens? So if it's been less than 5 years and you've owned that property within that 5-year period, then that would be considered an asset, even if you've moved that property to a trust. That would still be considered within that 5-year look back period. Where are wills filed and where's the best place to keep a copy of your will? You don't have to file your will. Some people choose to take it to the Register of Deeds for safekeeping. You have that option, but you don't have to. The only thing I advise is that when you take it to the Register of Deeds, it becomes public record. So anybody can go and look through that estate file and see, oh, Tia has a copy of her will. So I just suggest keeping it in a safe place, in a lockbox. Some of the banks have a safe deposit box. somebody in our community, we like to keep things under the mattress. Slip it under the mattress, but just keep it in a safe place. Next question was, how do you add grown children's names to your current deed? So you would pretty much just be getting a deed drafted and you would add their names on. And so I'm able to help with that process, but it pretty much would be getting a new deed, and you would sign in order to add your children's names to the deed. And then we would file that deed with the Register of Deeds. Next question, there's an inherited home, and what is the cost of changing a deed to reflect ownership by one adult child, but living rights for the other? So that would be getting a new deed drafted. And so you would be having the property in your name, but you would create a life estate right for the other person. And so our fee for a deed is $281. That includes the attorney fees, and then that includes the fee to file it with the Register of Deeds. So I think I got through all the questions. I'll wait a little bit for some more questions. Also, in the chat, I will share my contact information. That way y'all have it if you want to reach out to me. That way we can, look at your specific needs.
So Tia, I do see a hand that has been raised. We can allow them to speak.
Yeah, that's fine with me.
Okay. She put her hand down, so.
Okay. I got another question. It says, can you assist a client who resides in another county of North Carolina? I can. For the wills, power of attorneys, we can schedule a Zoom consultation, and that way I can help you with those documents. For estate administration, if you were to hire us to administer an estate, I typically stick to Nash, Edgecombe, Wilson, and Halifax, just due to the need sometimes to travel to those courthouses to pull certain documents. So those are the counties that I cover for estate administration. But if you need a will drafted, power of attorney, want to draft a trust, we can make it work to get that covered. Next question, is it okay if your name is not on the deed when you inherit property? My attorney says the names did not have to be changed when the estate was closed. That is accurate. So real property transfers automatically. So there may not be a new deed if you inherit property. And so you don't typically need a deed. You can get a deed drafted, but you don't have to have one. Next question is there a cost for initial consultation? So my consultation fee is $100. And so if you mentioned that you were on the webinar, I'll be willing to give a discounted rate for the consultation fee. Next question, do you recommend my husband and I to do an estate if we only have one child? So for, when you say do an estate, if you're talking about the power of attorneys or the will, I would recommend, putting those documents in place. If you have one child, if you don't have children, if you have 4 children, whatever the case may be, these documents allow you the opportunity to make decisions. And so I would recommend, in your situation, whatever your situation may be, to look at to putting these documents in place.
Tia, I do see another hand. I'm going to see if
Okay.
Miss Green, if you can unmute yourself. Maybe not.
All right, I got another question. If your name is on a deed with another relative who has a guardian, what rights does the guardian have when executing the will? So if I'm understanding your question correctly, you're on a deed. There's a relative who's on the deed, and that relative has a guardian. So the guardian, it depends on, what that guardianship looks like, and what the court has laid out that they're allowed to do. And so that's kind of more of I would need to know a little bit more details in regards to that specific situation, to figure out, kind of what the rights are with the guardian and what the guardianship allows. Next question, is there a time limit on how long you have to administer an estate? There is a time limit, and I am not afraid to say I don't know it off the top of my head, but I can find that answer and I will let you know. Next question, should parents of young adults complete any other forms besides healthcare power of attorneys to assist them with healthcare and their finances, managing their savings, check-ins? Should they be incapacitated? So in order to get a power of attorney, you have to have the capacity to do so. You have to be 18, you have to be of sound mind. So if that person is of the capacity to get a power of attorney, then, a power of attorney can help them, grant their parents permission to, or the ability to help them with some of their decisions, and things that they have going on. If they're incapacitated, then we start to fall in the realm of guardianship, because if they're incapacitated, they don't have the ability to effectively authorize an agent to act on their behalf. And so if you want, we can definitely set up a meeting to talk about how guardianships work. After probate closes, if a debt presents, does it have to be addressed? So during the estate administration process, there is an ad placed in the paper to notify creditors, and the creditors have 90 days to respond with any claims that they may have. So they have that 90-day period to respond to those claims. So those are the ones that we're going to be addressing, are those ones that respond within that period, that time period. Next question is, how does one become a power of attorney for a coherent aging loved one? The aging loved one needs to do what? The aging loved one needs to consult with an attorney and let that attorney know who they want to act on their behalf, who they want to name as their agent. And then they can also specify what areas they want them to be able to handle, if not all. So banking, financial, taxes, real property, or they can say, hey, I want them to be able to help me with all of these things. So just consulting with an attorney and getting that document drafted up. And to answer the question for, is there a time limit for how long you have to administer an estate? The estate needs to be opened up within 60 days of the individual passing. And then as far as how long you get to administer the estate, the clerk will put certain deadlines on when things are due. And so if you need an extension, oftentimes you will have to ask the clerk for permission and give a good cause reason as to why you may need an extension or why you may need to extend that deadline. For example, if you're waiting to hear about a retirement account that dad owned and you're waiting to hear back, from that retirement company, then you may need to ask the clerk for more time because you're waiting to hear back. But you have to have a good cause as to why you need additional time. Any other questions? Okay, I hope I answered everything.
Well, Tia, we can try one more time. We have
Okay.
we have someone who has their hand up, so I'm going to ask them to unmute themselves and see if that works. Okay, she put her hand down.
Got another question. So follow-up question for the aging loved one. Can this be a Zoom or does it have to be face-to-face? It can be a Zoom. However, that individual is going to need to sign that power of attorney document. If you're within the local area, I don't mind traveling. I don't mind doing home visits. Or if you're able to bring your loved one to the office and they need to remain in the car, I don't mind coming outside to have them execute that document. So just let me know what you're in need of and I can help get that document executed. All right, well, I hope that I shared some information and kind of explained some things. I hope that you all will think about these instruments, and work to put some of these things in place because they're very beneficial. And again, now is the best time to put these things in place.
Good evening to everyone, and thank you for joining us this evening for the estate planning webinar. Special thanks to Attorney Tia Hudgens-Taylor, our presenter this evening. Additionally, special thanks to all program participants and those who provided support. We hope that you found this presentation this evening or webinar to be informative as well as helpful. We also want to encourage everyone to complete the survey. The survey link is also in the chat. In addition, the survey will be mailed tomorrow via Zoom to your registered email. We highly recommend that you complete the survey and return it to us. Thank you again for attending, and have a good evening.